Some news out of the South Carolina State House on the issue of medical marijuana, which is something this news outlet has been tracking for several months now. This is an issue that's garnered significant attention here in the Palmetto State. And those of you who are regular readers, subscribers, viewers of FITSNews know very well where I am on this issue. Kidding. But seriously, I'm a libertarian. So yeah, medical marijuana, recreational marijuana, I'm all for it. Smoke them if you got them, people. Anyway, the opposition to medical marijuana, though, is still fairly established at the South Carolina State House, although not as established as it has been in years past. And we saw that on display earlier this month when Senator Tom Davis' bill, the Compassionate Care Act, S-150, passed the state Senate by a vote of 28-15. Now, on the same day that bill passed the Senate, it was referred to the House of Representatives, which will now either amend it and send it back to the Senate or pass it and send it on to the desk of Governor Henry McMaster to decide what he's going to do with it. Now, as we've been following this process, some interesting dynamics are taking place in the House of Representatives. Now, for those of you who don't follow this process, there are 124 members in the House. And as of this writing, only about 40 of them have committed to opposing this bill. That means the bill has got a really good chance of passing. And based on the vote in the Senate, you can obviously see where the math is going on this legislation. The bill is going to have enough votes to pass. Now, those who oppose medical marijuana know this. And so rather than having a debate on the bill's merits, which, again, they're obviously going to lose, they've decided to engage in some procedural tricks. The first trick has been to load the bill down with amendments at the committee level in the hopes of delaying it, stalling it, maybe even tripping up the bill at a very early committee process and keeping it from getting to the floor. Now, that's probably not going to happen, though, because the committee that this bill was referred to is actually one of the only committees in the South Carolina House that's actually controlled by Democrats. And most Democrats, they're down with medical marijuana and, for that matter, recreational marijuana. So this piece of legislation is going to clear that committee. So what's the next move? What's the next trick in the bag of those who oppose medical marijuana? Well, it's a very interesting play. What they're doing, and I'm told by multiple sources who witnessed this conversation at the South Carolina State House this week, they are engaging a former solicitor by the name of Tommy Pope, who is the number 2 official in the House, Speaker pro tempore of the House, in an effort to get the Attorney General to issue a letter declaring S-150 unconstitutional. Now, wait a minute. This bill just passed the Senate with overwhelming support. It's got overwhelming support in the House. Why on earth could it be constitutional? What are they talking about? Well, what they're referring to is a very antiquated section of the South Carolina Constitution, Article 3, Section 15. And that constitutional section essentially states that any bill regarding revenue must originate in the House. So if it's a bill that's about raising revenue, it has to start in the House, then go to the Senate, and then go to the governor. Now, is this true? Well, yeah, on its face, there is a constitutional prohibition against revenue bills originating in the Senate. But we did some research on this, and it has to be a pure revenue bill. In other words, a specific tax increase, a specific fee hike. If the bill is related to the police power of the state or any other power of the state, and the revenue component is incidental or ancillary to the main purpose of the bill, it doesn't qualify for that prohibition. In fact, there's not one but 2 state Supreme Court rulings which have affirmed that. But here's where it gets really interesting. The guy that these anti-pot lawmakers want to weigh in on this debate, the Attorney General, Alan Wilson, guess what? His office has already weighed in on the debate. In fact, it did so back in 2015 on a separate issue, but the same question. And in that issue, a bill was raised where, once again, there were questions about whether or not the revenue portion of the bill was the main focus or was it something incidental or ancillary. And the Attorney General ruled that if it's ancillary and if it's not the main purpose, then guess what? That constitutional prohibition does not apply. So it's very interesting that now the Attorney General, they're going to him in the hopes that he's going to pull a rabbit out of his hat for him when, in fact, he's already ruled on this issue. And, in fact, he's already taken the exact opposite position that they want to take. Now, if I've lost you with all that Constitution mumbo-jumbo, I'll boil it down to you much more simply right here. Opponents of medical marijuana do not have the votes to block this bill. And so they're resorting to every trick they can find, every trick they know,
to try and stop it via gimmick. Will they be successful? Well, we'll find out soon, but based on what we've been able to uncover at FITSNews exclusively, by the way, and I'm referring again to the Attorney General's previous opinion on this, they're not going to be able to get away with it. Because guess what, folks? The Attorney General's office has already ruled on this, and he's ruled that bills like this one are legal, are constitutional, and that's going to be a major defeat for those who are opposing medical marijuana in South Carolina. Again, stay tuned to FITSNews. We're going to keep you up to date on the very latest developments on this bill and other important legislation impacting you.